evening, everyone. This is Rajesh Ghosh from Indian Chamber of Commerce, Head of Economic Affairs. Welcome to our 7th episode of ICC Biz Live, our knowledge show for corporates. Today, our topic is exports. From is on exports, legal view. Now, the star speakers we have are Abhishek Gupta, partner MZM Legal, and Chirag Naik, associate partner MZM Legal. They are white collar criminal lawyers. They have an impeccable record of handling corporate cases of arbitration and other export related issues. So they are the best speakers to speak on the subject. So we are with this brief introduction, I would like to begin today's dialogue and request the audience to keep posting their questions from time to time so that your knowledge gaps get fulfilled. And we have brought these two star speakers for you only. So let me begin first. Question is promoting exports legal view. First question is on currency. Now, and the rupee dollar movement of lately, we have seen the rupee falling against the dollar, and government RBI's efforts to prop up the rupee. We all know that falling rupee is good for exports. True, but a huge fall affects our imports and affects our domestic inflation rates, and monetary policy goes into a tizzy. So the question is, what is your opinion on currency risks, and how India is managing, and how should an exporter look at it? Do they manage risk by taking forward covers, or they keep it open? What the question any one of you can take? And
okay, should I go, Chirag?
Yes, please.
Okay. Thank you for the question, Mr. Ghosh. So, currency risk is a critical factor in international trade that we all know. Now, the main impact of the currency risk in international trade, we believe, is on the competitiveness of our export and the overall economic stability of India as a sovereign nation. Now, when the depreciation of our currency, that is the Indian rupee, is managed and calibrated by the central bank, that is the RBI, it becomes a policy instrument. And as any effectively managed policy instrument, it is beneficial for exports, and it also makes our goods and services more competitive in the global market. However, sometimes this depreciation is either not controlled by the central bank, or, as happens in the economic life of nations, the central bank is unable to control the calibration as well as it thought it could have. In these cases, we see a free fall in the valuation of the rupee, like we are seeing right now. And such depreciation can have negative consequences, including higher import costs, inflationary pressures, and difficulties in serving external debt. Now, because we are on 28th February 2025, the one name that is dominating global headlines and keeping global policymakers up at night is, of course, Mr. Donald Trump. His second term, often referred to as Trump 2.0, has raised concerns about the resurgence of the dollar hegemony. And we all know that Trump 1.0 had a pretty aggressive position, an aggressive stance on economic nationalism and trade protectionism. So, therefore, given the measures that Trump 2.0 has declared over the last 3 to 4 weeks, it is quite plausible that the same policy might see a return to the global center stage. Of course, it goes without saying that a strong dollar would create challenges for emerging economies like India by making imports more expensive and increasing the cost of servicing dollar-denominated debt. I believe that the latter problem of the dollar-denominated debt is higher. And in addition to these difficulties, tariff impositions, which have already been levied by the administration, by the American administration, would force a tighter stance for global financial markets, and it could further impact India's trade dynamics and foreign exchange reserves. Now, am I audible? Okay.
Very well, sir.
Thank you. So there are two potential alternatives or alternative currencies that global trade sees itself moving towards, especially in light of the recent global conflicts, some in Europe and some in Middle East. And trades have lately been settled in these currencies. First is the Chinese yuan, and the second is the euro. Both these currencies have achieved or a degree of importance in the eyes of commercial stakeholders who have realized that it is possible to settle trades in terms of these currencies rather than limiting themselves to the dollar. However, the problem is that the dollar remains deeply entrenched because of its dominance over the last 5 decades, and the spate of executive decisions we saw emanate from the United Nations would only increase the dominance of the dollar, thus eclipsing the yuan and the euro again for the foreseeable future. Now, the problem is that with that developing situation, the problem is that higher interest rates charged by the Federal Bureau could create capital outflows from emerging markets like India, weakening the rupee further. It is possible, and while we are lawyers and it is not in the realm of our expertise, but given the nature of the question, I would like to mention that it is possible to mitigate currency risks if India chooses to adopt a multi-pronged strategy that includes strengthening foreign exchange reserves, deepening local currency trade agreements, and encouraging exporters to hedge against forex fluctuations, enhancing economic fundamentals to maintain investor confidence. Additionally, India should also consider fostering regional trade blocs with Southeast Asian countries and possibly promote digital financial solutions like digital currencies, towards which the Reserve Bank of India has already taken few steps, of course nascent ones, by promulgating relevant guidelines. To conclude, while a controlled depreciation of the rupee can be advantageous for exports, excessive volatility possesses risks that need to be managed through prudent monetary policies and strategic trade engagements. Trump 2.0 and ensuing economic policies would reinforce the dollar hegemony, and it would necessitate proactive measures to diversify currency dependencies and enhance financial resilience in India's export sector.
It really gives a good clarity to us. Now moving towards the contract drafting, which is your expertise area. Can you throw us throw some light on how should the export contract be drafted? Where can I as an can any ordinary any corporate just getting an export contract do it, or do they need legal experts like you, and if so, how? And lastly, does artificial intelligence help in drafting by scanning previous contracts? Do you keep previous contracts in hard form or soft form? So yeah, unless they're in soft form, the AI will not be useful to you, of course. So come on. So I would be grateful for your knowledge on export contracts. Thanks.
I think Rajeshi, very simply put, as a businessman, what you need to keep in mind is simple things. I think as businessmen, what you need to keep in mind is first things first, the terms of payment. See, all of us are more or less concerned with the payment. So the contract that you drop in an international transaction where the counterparty is out of the country, the first things was you very clearly lay out what are the terms of payment. Then, secondly, what you should really concentrate on is the delivery obligation. How, at what point in time are the goods deemed to be delivered, until when, who's in custody of the goods. So that is number two. Number three, if there is a dispute, how will you resolve it? Of course, going to court is an option, but there are various steps that can be taken before. In the interest of time and keeping in mind the local sensitivities and the local jurisdiction in question, you could tie in obligations for mediation and arbitration, which could make litigation or dispute resolution much more cost effective and time effective. Then number four, what is the legal recourse that the parties would take in case of non-payment for whatever reason? I think these are the key elements that are should be, included in a contract, and you should also be very careful about what are the laws which govern the transaction, which countries' laws apply. If there is an arbitration, where will the arbitration take place? This is a very important question because we need to know the jurisdiction and the seat of the arbitration would really decide what the costs of the arbitration are also. Whether an arbitral award will be enforceable against the other party. Then, in case of security measures and payment terms, you need to know whether it's a bank guarantee, it's an LC, penalty clauses. So, these are the major things you need to keep in mind while drafting a contract. Now, what has happened is if you are a smaller player on MSME dealing with a large corporation and exporting to a large corporation, you also have the uh, obligations that you need to sign. Sometimes you don't have a negotiating power with the other side, so you need to be very careful on what are the kind of audit rights that you are signing up to, what are the supply chain quality standards that you're signing up to, because many a times what happens is you see a lot of exporters being stuck in the EU, especially in the the food processing industry. You see that goods are rejected left, right, and center, and then your facilities and the chemical side is subject to inspection by various agencies. So many people don't realize that, and they sign up to it, and the transaction doesn't go through, thereby causing loss to the exporter. I think AI is not a good method to look at contract drafting. I think AI is more a tool for lawyers and legal experts who are helping in the transaction. That is because in India, legal data and legal judgments are available free of cost on open source, and anybody can access them in the public domain, and AI can be trained on it. But that is not necessarily the case in other countries where the law is fluctuating. Number two, legal data is not available in the public domain, and because there are intellectual property issues, the data has to be paid for. So AI in general will not be trained in that. So that itself, shakes the foundation of any AI helping you draft. Of course, if there's a legal expert who's using the help of AI, because the legal expert knows the local law very, very well, they can draft a contract safely. But AI is not a good method to draft any contract. You should consult legal professionals. Prevention is always better than cure. uh, if you don't take these steps in time, it could be very, very costly for you. And sometimes it is only a contract that can save you, because we will obviously discuss it later, but there are a lot of compliances also which are dependent on the contract. For example, your FEMA obligations, there is an obligation on the exporter to recover the money that have to be paid against exports. So it's not only an issue that you don't get paid by the importer in the other country, but you also have to then justify to the authorities why a payment against your export was not received, and there are penalties towards it. So I think that is what you should keep in mind, and you should be very careful while drafting contracts. It is the most cost efficient way to manage risk. Thank you, Rajashri.
I get it. I do learn that we need experts like you in drafting the contracts. Now, one simple question which is coming to my mind for an Indian exporter exporting to Bangladesh, well, if a dispute arises, which country's law should apply?
Of course, the law. See, the thing is, insofar as Bangladesh is concerned, there is a transitional government which is in power. So, we don't know whether the law which under which you entered the law and under which you entered into the contract will remain the same or no in the future. But with Bangladesh, things are very, very safe because Bangladesh is a common law country. The laws of the countries are much similar. So I would suggest keeping the seat of the arbitration in India or the governing law to be Indian, because the principles of both countries are quite similar, luckily. So Pakistan, Bangladesh, India follow similar principles of law. They are under the common law system which was left behind by the British.
So I would come to payments and later credits for ensuring preventing credit risks. But before that, I'm really curious to know about arbitration from expert lawyers like you. If after all the drafting and all the risks are taken care of, our default occurs, what is my recourse as an exporter? First, I
So
would
I think the
obviously
first,
knock at your
Rajesh,
door, and
your
then
first recourse will be to call Abhishek Gupta and then ask him a question on what to do next. So,
Uh, so recourse, and I'll try and present a practical solution rather than a technical proposition. So what I have seen in my experience is that the best recourse in any trade dispute and the most cost effective and practical recourse also happens to be a simple dialogue with your counterparty. The first recourse that I would advise any trader, any cross-border trader, is to simply pick up the phone, call up the counterparty, a reasonably senior person in the counterparty, and have a discussion with a bona fide and clear intent of settling whatever dispute might have arisen amicably. I've been practicing law for the better part of 20 years now, and I have seen that if two parties engaged in a commercial transaction have a bona fide intent of settling a dispute amicably without any attempt to take any advantage of the other party, then in 99 out of 100 cases, the dispute is settled without even the necessity of any litigation or dispute resolution process. However, what to do in the remaining 1%? So I would recommend that in the remaining 1%, as a matter of recourse, almost all international trade contracts have arbitration clauses, or almost all international trade contracts involve uh, trading instruments like bill of ladings, or for that matter letters of credit, which are also trading instruments which have inbuilt institutional arbitration clauses. So the second recourse that I would recommend is to try and examine all relevant documents involved in a particular trade very closely, and perhaps also share them with a counsel, so that a technical assessment of those documents can also be undertaken to identify any institutional dispute resolution mechanism available in those documents. Because the moment you involve an institution, you by default ensure a degree of good faith, and you ensure a degree of expeditiousness in all proceedings, which is typically missing in pure bi-party proceedings or approaching the traditional court structure. So please use as your next recourse a in-depth and technical examination of all your documentation to identify institutional dispute resolution. That can be mediation, that can be conciliation, or if necessary that can be arbitration or even suits where necessary. But if it's institutional, you'll be doing yourself a great favor in terms of time and cost, and also effectiveness of the end result of the dispute resolution. If at all you come up on a very rare situation where a frank discussion has failed, where institutional dispute resolution is not available, then regrettably you as a trader might not have much of an option but to approach the court of the geographical area where your counterparty is situated and presenting a suit, presenting your claims. That suit can simply be for damages that you have suffered, or that suit can be for directions on your counterparty to do or refrain from doing something. So, at a very high level, those are the few recourses available to a trader, an international trader.
Short, you are saying that an out of court settlement is always a faster way.
Absolutely.
Okay, now coming to the credit risks and coverage through taking protection from a letter of credit. Obviously, a letter of credit apparently on paper gives me guarantee of payment, but if the LC is issued by a bank like a small finance bank which recently went bankrupt, and even people are not getting their money, domestic people. So question, that bank will fail its LC. In that case, do I need confirmed LCs, and that too from a reputed or branded bank or with higher civil score? What do I ask for? Shouldn't confirmation, asking for a confirmed LC uh, add to my costs? But if my buyer says no, I cannot give you a LC, then so what is, and and another, I have also read about site LCs and usance LCs.
Mm-hmm.
On-site payment is always good, but if the buyer says no, I cannot give you on site, I want an usance LC of say 180 days. Up to 180 days is available, from 30 days to in multiples of 30 days, as far as I know. But they can be discounted and I can get payment. So explain this whole gamut of site LC, usance LC, LC confirmation, and protection from credit risk.
So, Mr. Ghosh, frankly, the entire issue of LCs is a pretty technical one, and one which involves a lot of gray areas. But I'll do my best to give you a high level overview of that. So, firstly, LC, otherwise known as a letter of credit, has been the most secure payment mechanism in international trade since, I will go out on a limb and say, better part of the last 3 centuries. So this instrument, the letter of credit, is literally the bedrock on which international trade is built. It is, at the risk of oversimplification, a guarantee from the buyer's bank that payment will be made to the sellers upon fulfillment of the terms of the LC. So if the LC says that the goods have to reach in a particular condition and that is verified by the authorities mentioned in the LC or the individuals mentioned in the NC, then payment will be made. It is literally a guarantee. And the necessity of this guarantee is because when you ship your goods, there is no guarantee of payment, or you do not receive payment. You receive payment upon delivery. While shipping your goods as a trader, you need some sort of a guarantee that as and when the goods reach the destination in the proper form, you will be paid. And the letter of credit has served that purpose. Now, while the letter of credit mitigates risk, it does not eliminate it. Now, there can be many situations in which risk is not eliminated. Some situations are downright criminal, where forged documents are used. But bar outright criminal activity, bar outright forgery, in the realm of civil activities or commercial activities, a situation where a LC does not completely eliminate payment risk is if it remains unconfirmed. So assume for a moment a letter of credit has been issued by a country which has political risks. For example, let's say Haiti. Haiti is facing severe internal political turmoil. Its banking system has weakened, and there is a possibility that the bank which has issued or which is guaranteeing you the payment of the letter of credit itself fails. See, there can be a lot of dispute here because the bank fails because of macroeconomic reasons. Now, largely, if a bank fails due to political risks or for reasons outside its control, macroeconomic matters, then it may very well result in non-payment or delays. Now, as you very correctly mentioned, to address this issue, sellers lately have been insistent on guarantees or counter guarantees on the letter of credit by a reputed international bank. The way it works is that, for example, assume a bank in Haiti issues the LC. However, that LC is confirmed by a second bank, let's say a Barclays based out of London. So the benefit is that while the Haitian bank might fail because of the prevalent circumstances, the probability of Barclays London failing is negligible. So if the Haitian bank fails to pay you, then Barclays will pay you. So therefore, while LC is generally typically issued by a bank situated in the geographical area of your counterparty, that LC can be seconded or confirmed by a bank which has a much better solvency in global terms, and thereby reducing your risks to get those LCs encashed. Now, of course, I would personally exhort you to insist on confirmation of your LCs by a reputed bank, because the terms and conditions are of many sales contract lately have been necessitating such confirmations by default. Additionally, I would also recommend due diligence on the issuing banks with some degree of monitoring the geopolitical conditions of the concerned bank, so as to ensure that the LC aligns with terms of international banking regulations such as the UCP 600. In conclusion, while an NC is a valuable tool for reducing credit risk, an unconfirmed LC carries potential payment risks. Therefore, it would be prudent to seek confirmation from a reputed bank to ensure financial security and safeguard against defaults by the issuing bank. Now, coming down to the issue of usance LCs and site LCs. Now, a site letter of credit is ideal for exporters as it ensures immediate payment upon presentation of shipping documents. However, some international transactions prefer usance or deferred payment LCs, which allows a credit period, for example, of 90 days before payment is due. In these cases, exporters often choose to discount the letter of credit to receive the funds immediately from a bank or financial institution. We call that financial product as a letter of credit discounting. It falls within the ambit of non-fund based financial products. Now, the discounting process involves selling a LC at a discount before its maturity, allowing the exporter to access working capital without waiting for the full payment term. For example, if you, let's say, have a LC worth rupees 1 lakh, you can go to, let's say, a State Bank of India and offer the LC for discounting. The State Bank of India might discount that LC at a 20% margin. The margin would simply mean the amount that would be deducted from the value of your LC and the payment that would be made to you. So in case of a 20% margin, you would receive 80,000 from that 1 lakh, and 20,000 would be retained by the bank, and that would amount to the bank's profit booked in that discounting transaction. So what you're doing here is you're fundamentally transferring the risk of the LC to the bank. You are running a risk with your usance LC, so you're simply transferring it to the bank by getting it discounted. Now, traditionally, discounting fees have been governed by the London interbank offered rate, but lately we have seen benchmarks such as the secured overnight financing rate in the US or the Eurobond in Europe. However, if an exporter approaches a domestic bank for LC discounting, the interest rates are typically linked to domestic lending rates in India, which are often higher than international benchmark rates due to factors such as inflation, central bank policies, and country-specific credit risks. Now, the detrimental effect of such discounting is that in highly competitive export markets, the cost of discounting can significantly impact profit margins. For example, for instance, in the example that I just cited, if you are agreeing to a 20% discount margin, then you have to ensure that your profit margin is at least 25 to 30%, failing which your business will literally run at margin, at cost, or even may start incurring losses. So therefore, in today's discounting is a sort of a situation where you have to choose between the devil and the deep blue sea. Now, for instance, if an exporter discounts a 19-day USENS LC at a high domestic interest rate, the cost effective of the financing could erode the significant potential of your expected profit, making the transaction itself redundant. So, in conclusion, USENS LCs are discounting USENS LCs is a viable financial solution. However, the choice of discounting bank and applicable interest rate is crucial. Exporters should carefully evaluate the cost implications and seek international discounting options linked to lower benchmark rates to preserve profit margins in a competitive global market. So, those are our thoughts on those queries.
In useful insights, but one question which comes to me is that very interesting is that LC could be forged. How do I check whether the LC is genuine or forged? Do I come to legal experts like you or go to my own banker?
Your own banker. Ideally, it is always the banker's obligation to assure you that the LC is proper in terms of banking channels. That's why a lot of these communications lately have been digitalized, so that you have various digital technologies, including blockchain, to determine authenticity. But nonetheless, as we say, criminals are almost always a step ahead of commercial businessmen. So forgeries nonetheless happen, in which case one will have to resort to the criminal justice mechanism. But to answer your question, it is the bankers whose job is to check the veracity of the LCs. And that is another reason why so many business entities choose to get their LCs discounted, because the moment you try to discount a LC, then the bank will take all necessary efforts to be doubly sure that the LC is genuine, because then it becomes an instrument in the bank's hand rather than your hands.
Now the next question is, what is a force majeure condition, which is circumstances beyond my control? What does the exporter suffer in such conditions?
Chirag, you want to take that? You're on mute.
Hi, Rajesh. You can pick up the question. Your voice got cut in the middle.
In exports, do I as an exporter suffer losses in such a condition?
Yes, you will eventually. If there is a situation like that, you will suffer a loss. But the thing is, there are legal recourses to recover it later. But yes, initially you will have to bear the cost of it.
No, I mean, can you give an example of a force majeure condition?
For example, there are many examples of force majeure condition. It could be earthquake, floods, hurricane, wars, riots, sanctions, economic crisis, pandemic, cyber attacks. You could have a government imposed trade restriction as well. So force majeure, see, we have learned from the COVID period. All of us have learned that many a times we didn't have the word epidemic or a pandemic included in the force majeure clause. So all the business persons have now very well learned that you have to include the words pandemic and epidemic in the force majeure definition. And the unique thing about force majeure is that you're supposed to have that clause very well defined as per the contract. Even if you miss out one word in the force majeure condition, then you have no claim. But force majeure itself will not allow anyone to claim for a loss or a claim for excusing the performance of an obligation or termination of the contract. You have to show that generally on the ground force majeure event prevented you from performing the contract. So that is a force majeure. Force majeure essentially means an act of God, an act which is neither in the control of either of the parties. These are conditions which are totally unique and they are totally unpredictable, which affect the performance of the contract.
The act of God reminds me of a movie. Anyhow, I won't be.
It generally is act of God. Force majeure is the act of God, so that is the translation. And that is how this concept came to be. Of course, this does not mean, just to clarify, it does not mean regular events which affect the performance. You can't say because there's a currency fluctuation, now I won't, perform the contract, or the cost of the raw materials have increased, so I can't perform the contract. So you have to really only the defined terms which are generally accepted a force major contracts, only those can be inserted. So you have to be very careful that very smartly the counterparty is not inserting terms in the force major clause which are generally not acceptable.
Okay. Yes, fine. Good learning. Now, next question is uh, export insurance. I had a meeting with ECGC some time ago where they had said that we offer insurance to exporters, but that protects against all sort of risks. But somehow they don't they are not inclined to the propensity to take insurance cover is going down. We going down. Maybe if they are saying it adds up to the cost, but I don't know. So I'm asking you your legal opinion on this.
So, frankly, sir, I think the reasons why our Indian traders, Indian international traders, prefer to avoid export guarantee are commercial, but nonetheless, I'll try and take a swing at it. So, if you see export insurance, particularly institutional export insurance like ECGC, is designed to protect exporters against risks such as buyer default, political instability, foreign exchange fluctuations, and shipment related losses. However, in my experience, one of the primary reasons for avoiding this apparently beneficial mechanism is cost considerations. That's what many of my clients have told me. Now, many exporters, especially small and medium enterprises, operate on thin profit margins that we were discussing during the LC question. And as we have realized that there are many factors eating into this already thin profit margin, including your letter of credit, which is unavoidable. Now, if you top that all up with the insurance premiums, which in some cases can be substantial, then it is quite likely that SMEs might not even be able to turn a profit, and might even, like we saw in the LC situation, be going into losses. So it is necessary to take a practical call here. For example, when let's say a SME is dealing with a regular buyer with a history of timely payments, exporters should assess the risk as minimal and decide to forego the insurance to keep costs down. However, if it's a new country or if it is a new counterparty, then it is prudent for exporters, even SME ones, to consider a practically affordable insurance. Now, the second thing or the second reason why people avoid export guarantee is the complexity and procedural delays. International trade, dominated by instruments like letters of credit and guarantees to letters of credit, is infinitely complicated for an organization which is small in size and scope, and which while makes a great product, is not very well versed in the intricacies of such business. However, the difficulty in export guarantee is that all such insurance policies come with lengthy documentation requirements, claim processing delays, and stringent compliance conditions. Most exporters find it cumbersome to navigate the formalities of the ECGC or private insurers, preferring to absorb the risks or go on financial instruments like bank guarantees, guaranteed letters of credit, which might not necessarily work in all situations. Also, of course, there is a situation where some exporters underestimate the risks. For example, an exporter who has never really faced a major default or shipment issue may rely on advance payments and perceived contractual clauses in relationships rather than go for coverage. Now, the difficulty is that such situations do not, let's say, account for political instability. For example, while a lot of Indian traders supplied FMCG goods to Egypt during the Egyptian uprising, during what we know as the Egyptian Spring, because of the political instability, relationships worth decades could not really help in making recoveries from those contracts. We are facing a similar situation in Bangladesh. Indian traders have decades old trade relationship with Bangladeshi traders, but the recent political instability has literally frozen all most trade relationships with that country. So while those traders who end up underestimating the risks basis their experience in this business do so at their own peril. To conclude, export insurance is frankly quite underutilized in India because exporters prioritize cost savings, trust long-term buyers, and find the claim process cumbersome. However, given the growing unpredictability of global trade, exporters should assess their risk exposure carefully and consider using insurance selectively, especially for new buyers or large transactions. That was us, sir.
Very useful, sir. Now, now the question is on service delivery risk. How can I protect myself against service delivery risk?
So service delivery risk, frankly, is the most important risk. As we discussed a little while ago, over the last few centuries, the instrument called letter of credit was developed to protect exactly against such risk. But while we discussed that LCs did go on to form the bedrock of international trade and did prove effective, that effectiveness is relative. For example, in spite of the best LCs and guaranteed LCs and export credit guarantees, service delivery risk still arises. So, with that prelude, service delivery risk arises when the exporter of a service fails to meet the contractual obligations due to factors such as non-payment by the buyer, contractual disputes, data security breaches, geopolitical risks, or force majeure events. Now, whatever we have discussed thus far, you might notice is involved in this risk because it is the predominant risk in international trade. Now, unlike tangible goods, services cannot be physically insured in the traditional sense, but risks can be mitigated through contractual protections and financial instruments. One of the most effective ways to cover service delivery risk is through well-drafted contracts that includes clear payment terms, performance obligations, milestones, dispute resolution mechanisms, and indemnity clauses. At the risk of levity, you won't believe, but I have seen international contracts worth $500,000 being concluded on emails, and not very happily worded emails at that. So that is something that a prudent international trader should always avoid to insulate the business from service delivery risk. Now, if we think about the service exports or the service export industry, for example, information technology, consulting, professional services, contracts should define service level agreements, otherwise known as SLAs, deliverables, timelines, quality standards, penalties for compliance. Additionally, exporters can also use SBLCs. So SBLCs are nothing more than standby letter of credit, which act as bank guarantees. So let's say Bank A gives you a letter of credit, and Bank B gives a letter of credit to Bank A to doubly insure all parties involved, so that the trade credit insurance to protect against non-payment. Now, in the case of software exports, patent infringement is a significant risk that is undeniable. Now, when intellectual property, that happens mostly when intellectual property is unclear or when software involves proprietary algorithms, source code, or business processes. Now, we live in a world where freelancing is a commercial reality. Unfortunately, a lot of freelancing services are provided by experts who, while brilliant in their technical fields, are not particularly well aware of the legal implications of using their brilliance to provide intellectual property to a buyer and protecting it in that process. So they are completely unaware of the fact that many countries have strict patent laws governing software, and even unintentional violation of existing patents, which can lead to legal disputes, financial penalties, and even restrictions on software distribution. For example, risks can arise if an Indian software company exports products that inadvertently infringe on patents held in foreign jurisdiction about which this company is completely unaware of, where laws might differ significantly from Indian patent regime. For example, this is a conflict we often see in European intellectual property law and Indian intellectual property law, where Europeans are held to a higher standard and Indians are not, leading to international disputes related to intellectual property, software exports, patent infringements, so long so forth. Now, it is also important to point out that cybersecurity and data protection also pose additional risks in service exports, particularly with privacy laws such as GDPR in Europe and CCPA in California, which is also broadly followed. Compliance with international data protection regulations is crucial to avoiding legal penalties and reputational damage. To conclude, service delivery risks can be mitigated through strong contracts, financial instruments, and legal safeguards. For software exports, patent infringement risks must be proactively managed through IP due diligence, legal compliance, and contractual indemnities. As global trade in services expands, Indian exporters must stay vigilant about intellectual property laws, data security, and evolving frameworks, regulatory frameworks, to ensure smooth operations.
Very good
That's our position.
learning point for me, because what you're talking about, patent laws being strong in one country and weak in another country, was very useful. I am an author myself. I have several publications. I have seen plagiarism. Plagiarism is a major crime in some countries, but and they have a plagiarism up to 10% acceptable. But in some countries, plagiarism up to 30% is simply not punished at all.
Yes.
This kind of difference I have seen as an author, as a researcher. So you're throwing more light on it. And now, question on this patent infringement. Another question comes to me, sir. I keep on studying, so I'm just loving this conversation. This. Does this patent infringement apply to open source software, or no? Those are there for learning from those who posted it in Google. Do they want to learn for further improvisation?
So that's an interesting question, sir, because ideally, intellectual property infringement, whether patent or copyright or trademark, should not apply to anything which is open source, because open source is the one exception to intellectual property exclusivity. However, there is a bit of an exception here. That exception is that, assume for a moment that you develop open source software, but one element of the software, even if a very small element, is copyrighted by an entity whose permission you have not taken to create the open source software. So I use that open source software to develop my web app. Now the entity whose copy or intellectual property has been violated while forming a very small part of the open source software can nonetheless have legal rights, depending on the jurisdiction, to sue not only the developer of the open source software but also their users, and in most cases demand a fairly substantial compensation.
Only this conversation is only telling me one thing: we do need people like you in exports. Now, the next question is, what are the compliance issues on both sides, from the exporter's point of view and from the importer's point of view?
So once again, this is a question one can write frankly a book on, but I'll try to summarize my answer and share with you some high level thoughts on the matter. So it's evident that exporters must comply with various domestic, international regulations, especially regulations of the importing country, to ensure smooth transactions. In India, for example, compliance begins with obtaining a import-export code from the Directorate General of Foreign Trade, without which exports cannot take place. Then, proper classification of goods using the harmonized system code is essential to avoid customs issues and incorrect tariff implications, which, please keep in mind, might have penal consequences. Exporters must also comply with the Foreign Exchange Management Act regulations, ensuring that all export proceeds are received through authorized banking channels within the stipulated period. And again, please keep in mind that violation of these rules have penal consequences, which would involve the Enforcement Directorate, both as a regulator of the FEMA and as enforcing authority of the Prevention of Money Laundering Act. Now, lately there have been additional requirements under GST norms which exporters have had to follow, where exports are zero rated, but proper documentation is required to claim input tax credit refunds or IGST exemptions through letter of undertaking. Limiting ourselves to the Indian context, another critical compliance area is export documentation, which includes the commercial invoice packing list, shipping list, bill of lading for shipments for sea shipments, or airway bill for air shipments, and export declaration forms required for customs clearance. For goods benefiting from preferential tariff treatment under trade agreements, exporters must obtain a certificate of origin that Indian Chamber of Commerce provides. Now, we all know that the ICC is one of the biggest institutions or biggest authorities which issues the certificate of origin in India. The preferential certificate of origin is issued under the free trade agreements, preferential trade agreements, and generalized systems of preferential schemes, allowing for reduced or zero import duties in the importing country. On the side of the importing country, exporters must ensure compliance with customs regulations, product quality standards, safety certifications, and labeling norms of the destination market. Some products require pre-shipment inspections and approvals, such as pharmaceuticals needing US FDA clearance or electronic goods requiring CE clearance for the EU. Additionally, exporters must verify if their products are subject to anti-dumping duties or import restrictions in the buyer's countries. Intellectual property compliance, as we discussed a little while ago, is another very crucial aspect, especially for software, pharmaceuticals, and branded products, as patent or trademark violations could result in legal actions. Of course, I would like to reiterate that the ICC, our host today, plays a crucial role in issuing certificates of origin, ensuring that products genuinely originate from India. And it is very important to keep the compliance challenges that we briefly discussed above in mind. But as I began by saying that this is a topic on which one could literally write a book on. So please take this discussion as a guide at best, and do take technical support and, if necessary, legal support for all material transactions.
So my next question is, if I have taken care of all the compliance measures, then do I still have any legal risks to face? Or this is assuming, I mean, you answer me. If if the compliance measures are taken care of, are there still legal risks remaining? And what is the legal risk, by the way? I mean,
Frankly, sir, assume for a moment that you are involved in a transaction which is compliant from the perspective of all involved stakeholders. That would be the exporter, that would be the shipping agent, that would be the shipping line, that would be the dockyard at your import destination, that would be the customs house agent, the clearinghouse agent at that end, and an importer and all its other agents involved. So if all these people are absolutely compliant in all respects, which surprisingly is the case in most situations, still there is legal risk. Now, as we discussed a little while ago, the first legal risk which transcends all definitions is the force majeure risk. The very definition is an act of God, which really transcends all our human attempts to be compliant with applicable laws. So force majeure risks still run high. The second is commercial dispute, a very simple commercial dispute, because when you say compliance, we are complying with external laws. Compliance does not really contemplate the commercial understanding of the parties involved in the transaction. For example, if A and B agree to sell scrap metal, exporting that from London, importing that into India at a certain rate, and there is a delay, a force majeure delay involved in that, and the parties agree that the delay is force majeure, but they cannot agree on the effect of that event on the rate of the exported iron. Then that is another purely commercial dispute, which would be precipitated irrespective of all your compliances. So that is another type of risk which is not really uh, dependent on your compliances. Now, it is also very important to keep in mind that there is a whole species of risk which arise due to differences in legal frameworks, jurisdictional complexities, trade policies, and enforcement mechanism across countries. Now, for example, as we just discussed a little while ago, assume a quick question of plagiarism. Now, in a question of plagiarism, the contracting parties, the publisher and the author, have agreed to certain royalties, keeping certain set of rules, keeping certain plagiarism rules in mind. Assume for a moment that that book gets published or read in a country with a third set of rules. That has the potential of creating a conflict and a dispute between the author, the publisher, and the reader of the book in the third country. Now, as I indicated a little while ago, one of the primary legal risks which is not compliance related is contractual non-performance. While the example that we discussed involved the rate of steel, it might very well be the quality of steel. The Indian importer might carry the steel, pay for it, carry the steel to its factory, and then discover that the steel does not smelt well, and therefore is not it cannot be considered to be good faith performance of the contract, which will then again result in a dispute. Now, then it is also possible that disputes arise even after all statutory and regulatory compliance due to ambiguous contractual terms and inadequate dispute resolution mechanisms. For example, as we had discussed a little while ago, just picking up the phone and speaking on institutional dispute resolution is one of the best mechanisms, but there are some times when that simply does not happen. And that is another big source of grievance and ensuing disputes. So, without touching upon compliance issues per se, another form of legal risks which has assumed a great degree of prominence lately is stem from sanctions and trade restrictions, where exports to certain countries or entities under US, OFAC, EU, UN, or other international sanctions can lead to severe penalties. Now, it is sometimes not evident in the transaction, and transactions go through and are completed, and a year later a regulator would turn up and say that your transaction was non-compliant with X or Y or Z regulation, and leading to a dispute between the transacting parties. So it is prudent for exporters to conduct restricted party screenings and verify if their goods require a special export license or regulatory approvals before shipping. So such is the nature of disputes which are non-compliance related.
One question coming to me is that suppose I send a sample for exports and my potential buyer doesn't like the sample, but and he doesn't pay me for the sample. I think that is the loss I have to bear under a stop loss principle or something like that.
So once again, it in my experience, it often degrades to a matter of dispute. As I said, if you agree to bear that loss, then that's a very mature commercial understanding that a person will take in a contract or in a transaction. But oftentimes, the fact that the product does not match the quality standards contemplated in the contract is itself a dispute. The exporter will appoint an expert who will say they match the contractual stipulation, and the importer will appoint an expert who will say they do not match the contractual stipulation. So the fact of matching the contractual stipulation is a dispute in most cases, resulting in dispute resolution processes across the world.
sir. Now, another question is, what is a political risk? I mean, if we do exporting to countries where the government is not sure, which are not friendly to India, what is a political risk, and how do I take protection?
So, frankly, political risks are almost always covered in the force majeure clause. For example, if you consider the situation in any country, in wartime Libya for that matter, after Gaddafi was disposed, Libya was a oil hub, and almost all major oil companies and oil and gas construction companies had large projects going on in that country. So when Libya was invaded and when Gaddafi was deposed, all those contracts went into a limbo, because as we know, after Gaddafi there was no smooth transition. Libya as a country is still divided into warring factions, but the oil and gas resources are still very much available in the country. They are still being mined, they are still being excavated, and oil and gas companies and the supporting infrastructure companies are still very much operating in that country. So one way of hedging the transaction against political risks is to have very strong force majeure clauses which are prudently drafted. Our tendency is to draft a force majeure clause which is a very vanilla one, which says that if there is force majeure, then the party who is suffering from the force majeure situation is exempted from all contractual obligations. The problem in that clause is that it completely fails to contemplate a situation where both parties might want to continue doing business even in a force majeure situation, but with certain tweaks to the underlying commercial terms, to the underlying contractual obligations, or for that matter, to the underlying service agreements. So, what the commercial world and perhaps commercial lawyers across the globe need to wake up to is the fact that force majeure clause requires as much diligence and as much work as a clause which contemplates service level agreements or scope of work. And this force majeure clause needs to be calibrated for that. For example, a force majeure clause needs to specifically contemplate the degree of handicap that a particular force majeure event introduces upon a party, and then contemplate a mechanism to address the degree of the handicap rather than assume that any force majeure would be 100% handicap. That would, of course, make force majeure clauses a little more complicated, bring in perhaps a few more annexures. But political risk in today's world is a very real risk. And plain vanilla force majeure clauses have almost always resulted in disputes which could have been amicably resolved had the force majeure clauses been a little more calibrated. So, to answer your question, sir, my suggestion to cover political risk in exports is to have a very well crafted and calibrated force majeure clause with expert inputs, keeping in mind the geopolitical situation of the exporting country, the importing country, and the shipping route, because we have seen the importance of shipping route from what the Houthi rebels, the havoc that the Houthi rebels wreaked on the shipping route passing by Saudi Arabia, so by Yemen. So therefore, the exporting country, the shipping route, and the importing country and prevalent geopolitical situations have to be kept in mind. And legal experts and geopolitical experts and trade experts have to get together to draft calibrated force majeure clauses.
Basically, what I learn is define force majeure properly. Otherwise, we may land up in trouble. Well, very useful learning. And now the last question, we have overshot our time very well, but no issues. We are enjoying. The question is, this is a finding I have to give credit to my Mumbai colleague Ratish Nair. He had we had organized discussion from where it became evident that export, after all the research taken care of, export price data is stolen by our neighboring countries, and they use it in predatory pricing, which is often used in the case of e-com and q-com in India. But they have been stolen, and export pricing data have been stolen, and then they have been used in predatory pricing against and eating into Indian markets. So, how do we protect ourselves from that? This is the last question for this.
So, quite frankly, sir, I would say that this question is again. So, had this been a domestic question, for example, had the theft occurred between two companies, both situated in India, the possible recourse would have been much simpler in the sense get the criminal justice system involved. But the moment the predatory pricing and the theft of data is by a sovereign entity, then there is no way of global enforcement of policies. One cannot really, one at best can issue demarches, one can try and find a diplomatic solution, one can even try, if situation gets really out of hand, to try and impose a commercial blockade. But short of a consolidated global response, there is nothing that one country can do to deter another from stealing export price data or engaging in predatory pricing. However, assume for a moment that a large part of sovereign nations agreed on norms which might look similar to something like the globally prevalent Basel norms, or for that matter, the globally prevalent norms on governing cybercrime. Then all these countries could could put in global procedures by which companies operating in their sovereign jurisdictions would be precluded from even trading with a country which would find itself in a negative list of sanctions, having stolen exported data, having stolen export price data, and having engaged in predatory pricing. To try and illustrate, assume for a moment that a country A engages in data theft and predatory pricing, and you have an international consensus, an international treaty governing such situations. Then the treaty organization could have a blacklist where the aggrieved country could apply for the blacklisting of the perpetrating country. And if the perpetrating country is blacklisted, then all entities operating out of the country would be prevented from benefiting from that stolen data, benefiting from that pricing, because international trade would be stopped with those companies. So, in terms of solution, that is the only thing that occurs to me.
So it seems there are some questions from the viewers. Can I
Mhm.
ask my media colleague to put up these questions, please?
Okay. So I think there was a bit of a discussion on that. There was a question which discussed compliances. So yes, there are websites which will help with import export situations, and the first step towards doing an import export business is obtaining the code and getting a good hand on the harmonized system.
Something of bank situation in Sri Lanka.
So quite frankly, I'm not really a geopolitical expert. So from an absolutely layperson's perspective, would say that it is quite bad. And as we discussed, the very fact that a bank is ready to issue a LC on site or a DP by site is not enough. That bank needs to be credible enough to pay that LC or DP. So whether you will be able to, whether that Sri Lankan bank will be able to make that payment or not is a question which is completely up in the air. So I would recommend taking a guarantee for that.
Any other questions? Or then further questions we get, we will send across to you, sir. With
Certainly.
this, thank you very much. It was really a good learning for me, and I hope for the viewers too.
Thank you, sir. We are
Thank you.
grateful for the
Good,
opportunity.
good
Thank you.
evening.
Thank you for having us.
Thank you.